Oyez, oyez, oyez. The Honorable Court of Appeals of Tennessee is now in session. God save the United States, the state of Tennessee, and this honorable court. Please be seated.
Good morning. Just a brief reminder that unless the court has put an order down, the cases will be live streamed on AOC's YouTube channel, and then the oral argument will be live streamed on YouTube channel, and then the argument will be placed on it. So what you say here is permanent, I guess. We'd like to welcome our newest judge to the Court of Appeals, and that's Judge Valerie Smith from West Tennessee, sitting here with us today. Call the first case, please.
Ajit C. Desai v. B.G. Naik Trust et al.
We'll hear from the appellant when you're ready.
Good morning, and may it please the court. This is a partition action.
You want to reserve any time for rebuttal?
Yes, I do, Your Honor. 5 minutes, please.
5 minutes, that'll be fine. Go ahead.
Partition action regarding commercial property. This was a fairly good-sized property. There were rental properties on it. Mr. Desai filed a lawsuit requesting that the property be partitioned, and it was partitioned.
Counsel, if you would, just kind of in front of the microphone. So
it was partitioned by sale. An auction generated $800,000. The two issues this morning are: one, ownership; two, allocation. Ownership: who was the other owner besides Mr. Desai? It had been Mr. Desai and Mr. Naik who bought this property as tenants in common in the 80s. And Mr. Desai, when he brought the suit, he brought it against the Naik Trust because Mr. Naik had died. Mr. Naik's will had a provision in it that devised this property, his 50% tenant in common interest, to the B.G. Naik Trust. So that's the first issue. Did the B.G. Naik Trust own the property at the time the lawsuit was brought? The second issue is allocation. There are three main issues on allocation. Mr. Desai has asserted, and the trial court proved, three modifications or allocation changes. Two of them were set-offs, I believe. You'd characterize it as set-offs having to do with the transactions concerning the property. One was Mr. Desai paid a loan of about $100,000. The property secured that loan, and his position was, I paid the loan, therefore I'd get $50,000 back from the sale proceeds, and I'll explain why that should not be approved. The other one is the property generated over the course of time this case pertains to, 2014 through 2020. It generated about $365,000 in rents. Mr. Desai takes a position that the expenses during those 6 years were $900,000. Therefore, there's no rent, no net rent to share. And that is nowhere in the evidence is there anything to substantiate that, particularly in the Ridley case, that addresses it head on. And the last one is Mr. Naik owed debt to Mr. Desai, which was an unmatured debt. When Mr. Naik died, Mr. Desai was required to file a claim in his estate. If someone holds an unmatured debt, of a decedent, the process is they file a claim, the estate puts aside money. When it matures, the estate pays. If you don't file a claim on an unmatured debt, you lose the right. It's barred by the time frame. So those are the issues, and let me go into them. The first one's ownership. Admittedly, if we lose ownership, we're done. But here's the history on that. The case was filed in 2018. The allegation in the complaint was exactly what we're arguing today. The allegation in the complaint was that Mr. Naik owned 50% of the property as a tenant in common. Mr. Naik died. Mr. Naik's will established a testamentary trust, and the property was devised, his 50% was devised to the testamentary trust. The complaint specifically cited the statute that is controlling. That statute is TCA 31-2-103. It governs the vesting of real property devised in a will. If a testator devises real property in a will, it vests in the beneficiary upon death, unless the will states that the property is to be managed and administered by the personal representative. We believe that's fairly clear. So that's what was alleged in the complaint. The trust owns the property because Mr. Naik died. His will conveyed the property to his trust. And the statute said it immediately vested. That was the case until just shortly before the trial. So for 4 or 5 years, it was the trust owns the property. That's who Mr. Desai sued as his co-tenant to partition the property. So that changed, and we don't think there's any basis for that. The trial court and the appellee have both argued that if you read the will, you will find a provision that says that the administrator will take charge and administer this property. But they've never really identified it. There is no place in the will that does that. It's devoid of any indication of that. The other argument they've made is that there's a marital bequest in the will that's for tax purposes so that spouses are able to take full advantage of the exemption. Mr. Naik died with a net estate of $996,000. The exemption was $1.5 million. So that didn't come into play. That is, in this case, is irrelevant.
Let me ask you this. What did the trial court say about the administration of the estate, or the lack, I guess more the lack of administration of the estate, and the fact that I think the trial court found that the trust basically had no assets because nothing was done? What did the trial court find in that regard?
The trial court found that the trial court actually found that the statute that I've cited did not apply. The trial court sent us to 2 statutes and said, here are the statutes that apply. One of them dealt with living trusts. If you create a living trust, the law in Tennessee now is that property that goes into that living trust must have a trail. If it's personal property, there must be some kind of conveyance, a bill of sale, something to prove that it's in the trust. But that only pertains to living trusts. And the court was confused, we think misled by the appellee. That doesn't apply to testamentary trusts. It's very clear. So that statute really did not come into play. The other statute was a statute that pertains to foreign wills. Well, this was not a foreign will. This was a Tennessee will. Now, the court, in a later order, sort of took those back. Said, I didn't really mean that. I was just trying to give you some direction about how you could handle this. because the trial court said somebody's got to go out and figure out who the other owner is. Because this case was tried with the plaintiff saying, we own half, we're entitled to these set-offs and recoupments, it'll make it more than half. We don't know who owns the other half. Now that's an unusual situation. Of course, our view was, and we think we showed at trial, that we did own the other half. So that's the first question for the court. Who owned the other half? Did Mr. Desai sue the right party? The other issues are the rents we talked about. Another one is that we talked about the loan, and then the other one is compensation agreements, where Mr. Desai did some special work on the two buildings that they built. And there were two letter agreements where Mr. Naik said, okay, you get $20,000 and another $25,000 in the other agreement when the buildings sell, when the property sells. That was a timing issue, and there had to be a claim filed in the estate. There was not a claim filed in the estate. That claim is barred, and Mr. Desai now takes a position in litigation that the letter agreements created no personal debt of Mr. Naik, and that it created a mortgage. But this mortgage statute in Tennessee is very clear. It says, here's what you have to have a mortgage. It actually gives an example, A, B, C, D, and none of that is there. So that's a recoupment. It's about $200,000. I see my time's up, and I'm running into my 5 minutes, so I'm going to quit.
Thank you. Yeah, you have your time for rebuttal. We'll hear from the appellee.
Good morning.
Good morning.
Justice Smith, my name is John Konvalinka. I think the other two justices may know me, but in any event, nice to meet you.
Mr. Konvalinka is one of our regulars.
I would call him a frequent flyer.
Always glad to have you here.
Justice Davis, the answer to your question is she found there was no assets that were in the name of the trust. Specifically, what she did was she looked, he said 31, it's 31-2103, that the statute that she's referring to. And the language in there that sort of takes away the, quote, immediate vesting is based upon in the part of the statute where it says, unless the will contains a specific provision directing the real property to be administered as a part of the estate subject to the control of the personal representative. This suggestion of the two statutes has been made by the appellant. She thought she confused the appellant because she was using illustrations or examples. He actually addressed that, and she addressed that in response to his motion to alter or amend, explained that. There's a transcript that provides for all of that. The issue in this case is, with regard to this administration of the estate, you are exactly correct. This litigation has a history that goes all the way back to 2001. There are two different related cases that we explain in our brief with respect to this. This is a situation where Malti Naik used to be married to my client. Apparently, there's still some heartburn beyond that divorce. So, again, with respect to this, we would suggest to you there's been no administration of the estate. In fact, what was done, the chancellor revoked the letters testamentary. Actually ended up having to hold Ms. Malti Naik in contempt. In our case, where we tried this particular case, which is a partition case, as pointed out by counsel, and it is a division of 50-50, and what the judge did at the end of the day with respect to this case, she decided what expenses and what amounts should be paid from the whole of the proceeds of it, and then said at the end what was going to be left would be 50%. She still intends to have 50% of the net proceeds available once the people come forward that should have standing with respect to that and demonstrate that they have standing. She said there was no proof as to the standing issue because she said the trust was never funded. And so she said, we're going to hold this money until such time as there is legitimate proof. One of the things is that in the will, that's a little bit, and there's a discussion beginning on page 137 through approximately 143 in volume 14 of the transcript, where Mr. Long and myself and the judge are having a discourse about the terms of the will. I would encourage you to review that. Among other things that's been said, right off the bat, Miss Maltignac and her brothers, who are trustees, have a mother. Her mother was still alive at the time of our hearing. The mother was the beneficiary for a portion of that real estate. She's not even before the court. Now, it's not like this is an ambush, which is what I think is being suggested by way of the original complaint. Fortunately or unfortunately, I was not the original counsel in connection with this. I was substitute counsel. But at the time that I filed my trial brief in connection with the trial, I put forth there was no standing on behalf of the trust based upon the discovery and the information that I had. The judge, this was in March, we had a case set for trial. The judge in March said, we're not going forward, Mr. Conway, because you've addressed this in your trial brief. To give the defendants ample time, we're going to adjourn, and they have, I forget what exactly the date was, it was sometime in May, we're going to have a time for them to add whatever necessary parties there are. So she asked them to please add whatever necessary parties that you have. Nothing was done in connection with that. So again, she was faced with the proposition, she didn't believe that she had people that had appropriate standing, that they had not demonstrated or proved their standing because they had done nothing with respect to the administration of the state other than getting themselves revoked, and actually one of them held in contempt for not doing things. And in fact, what the public administrator that was appointed, which was Mr. Michael Ohoyak, actually did a settlement report that is an exhibit as well, says they got 0 assets in the estate. He had 0, there was nothing in the estate. There are 3 different zeros he came up with in connection with this. There is a blanket assignment with regard to whatever interest that the, quote, estate may have will be transferred to, quote, the B.G. Naik Trust. And so there's been no proving of even establishment of the trust. The trust doesn't own anything. It's also a blanket assignment that actually has a wrong map and parcel number for the property in question that's on the assignment. It's not a quitclaim deed, it's just merely an assignment. I think in today's, there's a statute that prevents that from happening, and you have to have a particular deed. I think at the time, you could maybe have done it by a blanket assignment. But the point is, nothing was done. And the judge was faced with the proposition of, we're going to proceed in connection with this.
Counsel, let me add a very basic fact here, I guess. Or who did the trial court find, the petition suit, who did the trial court find was the owners of the property?
There's no question that the 2 owners of the property were 50% B.G. Naik and 50% Ajit Desai. The problem is that Mr. Naik died.
Yes. So who owned?
Well, that's her point. She hadn't had anybody come forward and tell her who owns it. They take the position that it, quote, vested immediately into the trust, and we take the position that it didn't vest immediately into the trust. In fact, they did nothing to manage that estate. And the will provides that the mother is supposed to be getting some share. So if you weren't dealing with an intestate state, right, you would be dealing with an intestate state, and so it would be the mother and the children. If you were dealing with an intestate state, you would look at the terms of the will. Again, the mother's mentioned in that will. And there is provisions that the executors and the trustees who were appointed were supposed to deal with and never were done.
All right, so before any of the offsets or any of that was done, you had the money. It was going to be divided 50-50 if there were no offsets. Your client was going to get 50%.
Yeah, I mean,
and who was going to get the other 50%?
Well, she's holding it in the registry of the court, waiting for somebody to make application for that. She
Okay,
said
so-
that at the end. She says, we're holding this money in the registry of the court on an interest-bearing account. When the, bluntly, she didn't give a roadmap, but she pretty much said, you need to go get everybody and bring them here so we can deal with it, because it's still there, and it's still, she can't force them to do that, but she's telling them, it's there. It's your amounts. Talking about the offsets quickly, with regard to the loans that we're talking about, one of them was a line of credit, $100-something thousand, obviously used by both Mr. Naik and Mr. Desai. The court found that what happened is that they didn't have the money, that is, Needy Enterprises didn't have the money to pay off the debt, and that Mr. Desai undertook to pay off the 100% of the debt, which is $100,000 approximately. She awarded him approximately $50,000 because it should have been, the tenants in common should have shared in that expense. Otherwise, they were going to lose. There was a lien on that property. If they had not paid that $100,000, they would have been foreclosed on with regard to that property. And so he paid off that loan. That's one of the offsets she has. There was two other written agreements between the parties. They were fairly old, but they were fairly specific. And fairly specific in the sense that Mr. Ajit Desai was awarded $20,000 in one particular year for the work that he had done in connection with the construction of one of the buildings that's on that site. And then but it said he could only receive that $20,000 if he sold it to Mr. Naik, or the property was sold at some point, and that's when he would be paid. He didn't get paid anything until such time as he sold the property. Now, again, if people wanted to sell the property earlier, they could have partitioned this a long time ago instead of having to send a derivative suit till 2018. But with respect to the other loan, it was $25,000, same thing, different building. He constructed it. He was given a promise to pay him for his work in connection with that. Again, when and if it was either sold to the other shareholder or until such time as it was sold, period. And so those are the two loans in connection with this. The other offset that's out there is that Mr. Desai, and this is pretty much a heated issue in connection with the case, Mr. Desai prepared documents indicating the expenses that he did with the trust. Actually did that in response to discovery responses. And I forget exactly what the numbers are, but I think it's exhibits 18 through 22 that are 70 pages long. There's been a suggestion in the appellate's brief that we had no proof of the underlying documents because he'd done a summary. So respectfully disagree, heatedly disagree that that's correct. Because, again, he apparently hasn't looked at the exhibits 18 through 22. They continue to refer to an exhibit that was marked for ID, to which I objected, and the judge sustained the objection because it was, quote, a document that was delivered during the third day of trial, which was, again, we went from May through October. We had 2 days in May, and I think 2 days, maybe a day in July and a day in October. But, again, on that third day, they presented a summary exhibit that had no underlying facts in connection with this, and the judge said it wasn't going to come in. Violation of Rule 1006 was also a violation of the local Rule 8 because it was not timely identified and put forth in connection with this, and there was no seeking of any relief from Rule 8 or giving any information under 1006. And so, again, that Exhibit 67 ID is splashed throughout the appellant's brief, which we take issue with because it's being used for probative value. They also make an alternative argument somehow it's a demonstrative exhibit. It's not a demonstrative exhibit. It is one that they use for probative value. They try to use it for probative value in connection with this appellant brief. And again, the judge actually said the document itself on its face was prejudicial because it was so inaccurate. Again, the judge labored over this particular case, and she wrote, as you will see, a 36-page opinion. I think she got tired after that when we did the motion to alter amend because she was prepared and dictated it, and then we added that transcript to the order, which was then tendered in connection with this. There is lots more to talk about. If you want to ask me questions, I'm more than happy to try to explain what it is. But at the end of the day, you got to ask yourself, what is it that the judge can do if you don't have a party? She did what she could do, which is the answer to your question. The money's there. It's earning interest. Knock on my door. That's what I would tell you.
I hear no more questions. Thank you. Hear from the appellant rebuttal.
There are a plethora of issues, so I'll try to address them and as I can. The comments about the relationship between Ms. Naik and Mr. Desai are completely gratuitous. There's not a skosh of any evidence that has anything to do with this case. And you can scour the record, and it has nothing to do with this case. The proof that was missing at the trial, I want to talk about in a minute. But here is a main argument that is made by Mr. Desai. His argument is, I own half, you don't own half, and you didn't go out and find the person who did. That's not what the statute says. The statute governing partition actions says that the movant, the co-tenant who brings the action, has a duty to go out and find the other owners. And if he can't find them, he's supposed to publish something in the real estate records. It wasn't our burden to do that. The judge said, I'm going to put the trial off 30 days, and if there's an indispensable party, let me know who it is. That was not our job. Of course, and we don't think there is an indispensable party other than us. We're the trust. The property came to us through the will, and still there has been no designation to satisfy this. It says real property of the testate decedent vests immediately upon death in the beneficiaries. The trust was the beneficiary, unless the will contains a specific provision directing the real property to be administered as part of the estate, subject to the control of the personal representative. When a will is drafted, what are we going to do with real property? If we designate it for someone, that's where it goes. If it's not designated, it goes to heirs. Only if the will says it's the personal representative is going to administer it, does it not go out immediately upon death. The proof that's lacking in this case for these set-offs is that the law is set forth in the Ridley case. I don't know if it's reported, but it's very persuasive. The Ridley case, and in that case, the party party moving for and filing a petition for partition of the property claimed $70,000 in expenses and came up with a list of the expenses. Here they are. I spent this much on this much on this, and the court said, where is the backup? Where's the proof? You've just given us a list. That's what Mr. Desai did. What he did was, as Mr. Convalinka said, in discovery, we asked, what did you spend this hundreds of thousands of dollars on? And we showed in the record that he had been spending per year like $5,000, $6,000, $8,000. And now all of a sudden, it's $15,000, $20,000. Well, he has monthly reports that he made up during the litigation, and it shows he's paying 10 credit cards. He was asked on the stand, what were those for? What were the credit cards used for? And he said, we quoted it, he said, I don't know, you figure it out pretty much. And then he said, well, it may have been used for the corporation. They owned a corporation. It may have been used for the corporation. We can't take their rents and use them for a corporation. That disproves their use. Next, the Regions loan. There's a loan of $100,000. There is no proof in the record whatsoever how the proceeds were spent. In order for Mr. Desai to get a set-off for that, he'd have to show that the loan proceeds were used to operate, administer, improve the property. No evidence whatsoever. What we're asking, we are asking that this court Take this case, take the money, that the proceeds of the property, deduct the attorney's fees, give Mr. Desai nothing for these compensation agreements because they're barred by the statute of limitations, give him nothing for the region's loan, give us a credit of $158,000 plus interest because of the $365 in rents. We got none of it. We used in that exhibit, which is a demonstrative because it wasn't admitted, we took what he was deducting before 2014. It was the lawn care, HVAC, there were like 4 categories, and it was very, very little. Once the 2014 came along, he quit paying anything and was deducting 10 credit cards. And he can't tell us where that came from. So that's what we're asking the court to do. It will require not that much work by the trial court. The trial court has to figure out interest and some minor adjustments. But it's attorney's fees off the top, split it in half, and the rent that the trust never received gets paid back to it.
Thank you.
Thank you.
Of course, thanks to counsel, both sides. Appreciate your briefs and your oral arguments today. It actually clarified some things for me, the oral argument did.